Following presentation.
There you go.
Okay, thank you. And if anyone wants to mute video as well, since it's being recorded, please feel free, though. I do personally love to see some smiling faces and nodding heads or even perplexed looks. All right. So I think we can probably get started. Do you want to do a little bit of an intro, or I'm happy to just launch right in, whatever you want.
You can jump right in if you want.
Okay, not a problem. All right, so my name is Moira Laidlaw. I am a partner at Hollis Laidlaw Simon, and I'm going to tell you just a little bit about my background, because when receiving advice in this area of how to finance long-term care, it's really important to make sure that you're in the hands of a trusted advisor. So I really only go into my background because this is such a complex area of the law that it's almost exclusively my practice area in terms of trusts and estates. I don't practice real estate. I don't practice commercial litigation. Like, there's a laundry list of things I don't do. What I do is concentrate my practice in the area of trusts and estates. I've done further training within that broad category in the area of elder law and special needs planning. I'm a certified elder law attorney, which means I went through a testing process to earn that designation. I also serve on our State Bar Association's executive committee on elder law and special needs. We lobby very proactively with the New York State and Albany to preserve some of the protections I'm going to describe today in our New York Medicaid program. I also have, done a fair amount of bar association work locally in Westchester County. I've been chair and of the guardianship committee for the Westchester County Bar Association, the elder law committee of the Westchester Women's Bar Association, the trust and estates committee of the Westchester County Bar Association. So all of that is just to say, like, this is such a complex area. You just don't want to go to a general practitioner about it as if you're looking for advice. And today's lecture, please feel free to add to the chat any questions you have, any clarifications you need as we go along. Jody is always really good in supporting me in these presentations in terms of interrupting me if I'm not clear about something. And so I always give Jody complete permission to say, hey, Maura, can you go back to this particular concept and clarify with that word or what you just described in a different way. All right, so in general, with financing long-term care, there are 4 different ways to do it. The first way is just to private pay. If a client walks into my office and they are ultra high net worth, they are, a married couple, they have upwards of 7 million or higher in assets. We're generally focusing those conversations on estate tax planning that we need to do and not elder law planning, because if an elder law event occurred, their investment accounts would be able to absorb a $600 a day expense, which is what nursing homes presently cost in 2022. So as we think about what they might cost in 2025 or 2028, I can only tell you the costs have never gone down, right? So that's just the sad reality of our situation. And Medicare benefits simultaneously have never been expanded to cover more. So Medicare is covering less and less. And that leaves my clients having to find other solutions to absorb this really bankrupting expense. So that is the first way to do it. The second way to cover a long-term care expense, besides just absorbing it privately, is to rely on insurance to cover it. So this form of insurance is generally known as long-term care insurance. When clients come to my office and they already have long-term care policies, I'm really excited, especially if the envelope looks ancient. And the reason why I get excited when the envelope looks really old is in the 1990s, when insurance companies first started offering this particular insurance product, they had no idea of the risk that they were taking. And so they gave really generous policies back in the 90s. They had no term limit on these policies, so they lasted my client's entire lifetime. And they had no dollar amount cap on these policies. So if a client is holding one of these policies, it's gold. And we definitely never want them to let the policy lapse. And on those policies, it's really important to contact the long-term care insurance company and give them someone else besides you as a person to receive premium notices. Because if a person suffers cognitive decline and they get a renewal notice and they don't pay the bill, then that policy is going to lapse. So really important if you have a long-term care policy, really important to get some advice on what the strengths and weaknesses of that policy are. And so when clients come to us already with policies, or if they are considering procuring a policy, we always start with a policy analysis. When the policies are newer, here are the drawbacks. There are still significant benefits to long-term care policies. I always want people, if they can afford them, to get it. And I don't sell insurance. Okay, so like I'm not making any money off of this recommendation, but I always want people to get it because long-term care insurance does a really good job, if it's a recently issued policy, of covering a light long-term care need. If you think about needing a few hours a day, a few hours a week, long-term care policies really cover that kind of presentation well, because they typically have dollar amount caps per day and they have term limits. So the most common policy I see is roughly $300 a day of coverage and 3 years of coverage, or 150 or 200, but like somewhere in that band of 150 to 350 a day, depending on how much premium cost my client could afford. And so the more affordable the policy is, the less benefit it comes with now, because the insurance companies have a deep, deep understanding of the risk that they are now taking. Most insurance companies have actually exited the market. So there's only a few operators out there that even sell insurance of this kind anymore. Genworth comes immediately to mind. So there aren't that many underwriters anymore, and they're much harder to get out of underwriting. So a lot of my clients who try to obtain long-term care insurance now can't get policies because they don't pass the underwriting exam. That's pretty exhaustive. If there's any history of anything that could make my client more vulnerable to a long-term care issue, the insurance companies are just saying, no, we're not taking you on. So even when clients have long-term care insurance, if it's a more newly issued policy from 2000 on, we're going to understand its strengths and weaknesses, and then we're going to do some additional planning. So the next option in terms of covering health insurance costs and the risks of health insurance costs is potentially Medicare. And it's a natural thing that the adult children of my clients are often thinking of. They're like, oh, Medicare's just going to cover this. Most of my clients who are in their late 70s, early to mid 80s, they're acutely aware of Medicare's strengths and weaknesses in this area. The adult children aren't. The adult children are pretty blindsided that Medicare doesn't cover long-term care. And so they have to get up to speed really quickly if advanced planning and discussions haven't been had. The problem with Medicare, just big picture, is it's meant and designed to be replacement insurance when we retire. So if you think of employment years when maybe you were covered by Aetna, United Healthcare, Blue Cross Blue Shield, Medicare is about replacing that kind of insurance. And health insurance fundamentally is about treating a client in the community and doctor's visits and in the hospital with procedures. It is not about providing unskilled care to keep someone safely in their home so that they're not a danger to themselves and that they can be assisted with activities of daily living so that they don't fall and have a worse health outcome. My mom was a nurse for over 50 years. And I don't know if I've told this story before. So this might even be new to Jody, who's heard like a million of my lectures over the years. But my mom came up in that era where instead of going to college, women largely became teachers or nurses. So my mom at the age of 17 went to nursing school. And then her nursing school had an attached hospital, and she worked at that hospital when she graduated. And then that hospital also had an attached clinic. And as she got older and, wanted a more flexible schedule for her children and just her own body, it's very physical to be a nurse, she then switched to clinician hours. And she worked on this city block in San Francisco for like between schooling and her whole career. She was there for 57 years. She worked until her early 70s. And I mean, just an incredibly remarkable, like giving nurse. I always just think so highly of the medical profession overall with what they do to care for us. What she told me once, and I didn't believe it at the time, it was literally like a dinner discussion, I want to say in my like early 20s. She told me that half of all deaths are caused by falls. And so if you think of the importance of getting assistance with activities of daily living to prevent falls and that poor health outcome, it's just really important. And so I think it's a travesty, frankly, that Medicare doesn't cover long-term care, because it's a health insurance system designed to support people when they retire. Well, what are your health risks at that time? Your health risks are needing assistance with activities of daily living over time. And it's really just pure public policy and cost containment, and us not allocating funds to support people who've paid into the system. And, if I could wave my magic wand, I would have Medicare cover long-term care expenses, and I could go back to just being a traditional tax lawyer. But I can't wave my magic wand. And so instead, what we have to do is get very creative to find support through our state Medicaid programs, because our state Medicaid programs are what actually meaningfully cover long-term care costs. And so whenever I have a discussion with a client and they voice or it resonates with them when I raise the issue of whether they're concerned about how they would finance an unreimbursed long-term care cost, we almost always land at needing to develop a Medicaid asset protection plan. And it's that kind of planning where clients are just shocked that they're in a world where they are going to need to access Medicaid. Like most of my clients think Medicaid is for like really, really, truly impoverished, low income people, and that they will never ever need to receive that kind of state support. But the problem is that these expenses are so bankrupting and will wipe out a savings. And then my clients have to go onto Medicaid anyway, that to proactively protect the savings so that it can be used for other costs that Medicaid won't pay for, like significant, Westchester County real estate taxes. Like if clients wipe out their entire savings on unreimbursed medical costs, it leaves no other money to cover all the other expenses of living in New York State. So it's really important to proactively start to think about, what do I own? How do I own it? And how could I own it in a way that my family and myself would be protected if anyone in the family ever had unreimbursed medical costs of $600 a day? And that's the current daily rate at a nursing home. What is sometimes viewed as less expensive is home care. But I privately manage home care for a few clients who don't have family member supports. And when you do home care legally and there's a significant care need, I can tell you it comes very close to $600 a day. The cheaper home care is home care that's not supervised by an agency, that's not reported to the taxing authorities or the workers' comp or the unemployment board. And we end up having to defend people from fines because it is a high risk of an aide filing for unemployment insurance or an aide filing for workers' compensation if they get hurt. So if anyone's in a position, and it's really common when we first meet with clients, that they have an aide that they're paying cash under the table to, There's some magical thinking going on that the aide is an independent contractor. And I'll just tell you that it is a hard and fast legal rule that home health care aides are always employees of the family and are to be treated as a business and receive a W-2 stub at the end of the tax year. They're never treated as independent contractors who receive 1099s. So one of the kind of extra problems that we're able to solve for when we develop a Medicaid asset protection plan is we're able to get that aid onto the books and paid for by a licensed Medicaid agency. And then it cleans up the inherent risks that my clients are taking of being fined by New York State for not paying into the Workers' Comp Board or the Unemployment Board. And those fines can be upwards of $50,000, $100,000, depending on how long a person receives care. All right, so that is just like a super, super high level overview of the techniques and the issue spotting that we do in that initial conversation with families. I'm doing this a little less traditionally today, Jody, than I usually do, just because it's the 4th of July weekend. And I don't know if people are ready for like a 40 deck PowerPoint, which I can definitely turn to next. But I'm curious to pause at this point and just see if anyone has any questions before I get into the weeds of Medicaid qualification. I'm gonna just open up my chat thing. So feel free to chat, feel free to unmute and raise.
Don't have anything in the chat yet.
Okay. I'm gonna give it a moment to percolate and I'm gonna open up my PowerPoint slide deck and to see if anyone needs a little time.
Maura, do you see there's a question in the chat?
Oh, let me go back to the Zoom.
I can
I've got it.
I can read it to you. Are you going to address how to finance long-term LTCH policies as promised, please? LTCH?
I just want to clarify what the H means in that. So long-term care, what is the H? Long-term health care. Okay, so I'm going to interpret that to mean, how to pay the premium on a long-term health care insurance policy, like how to finance it. Here's what has traditionally happened in the last few years, I would say maybe the last 10 years at least. When the policies were initially sold to my clients, they were promised that the premiums would never go up. But then what the insurance companies did was go to New York State and to their insurance department and say, New York State Insurance Department, we're going to go belly up if we honor these policies as originally issued with no premium increases. And New York State relieved them of that obligation to not increase the premium and negotiated the following with the insurance companies. The insurance companies had to write all of their clients and say, you can keep the policy as is with this incredible benefit, but here's your new premium you're going to have to pay. Or you can opt for door number 2, which is reduce the benefit you're getting under the policy, but keep the premium payment the same. And, that angered understandably a lot of my clients. It felt like a complete violation of the compact that they had made with these insurance companies. And frankly, shame on the New York State's insurance department for not holding their ground and making the insurance companies honor their original promise and make less money on this particular form of insurance. So in terms of financing a long-term care policy, I think you have to view what that policy is now in light of your current income and what you anticipate your income will be when you retire, if you're not yet retired. But build in some sort of potential for a rate increase, even if the policy itself says that the policy won't increase over time. Okay, So there's another question. I'm just going to take a moment and read it. It's a long one. So it's not, which isn't a problem. It's just gonna I'm going to pause for a moment. Okay. All right. So thank you, Metzi, for that question. It's a really good one, and it's a way to start kind of the next chapter of the discussion. So with that, I'm going to go deeper into my PowerPoint slide, because by just sort of freelancing at the beginning, I was able to at least get a little bit of the first part of the presentation done. So let me do this one moment. Okay. All right, so I'm coming here and I'm sharing my screen. And again, still continue to post questions to the chat if you want, and Jody will let me know, and we can leave some time at the end.
And we can see it, Moira.
Okay, great. So whenever I turn to the weeds of Medicaid, I like to start with this quote from our New York judiciary. It's a really important quote because and decision. Because when we start to do Medicaid planning with clients and we transfer assets very commonly to irrevocable trusts, and we're sheltering assets from being lost to long-term care costs, it feels quasi-criminal, like, oh, is this allowed? Am I hiding assets, you know? And so I like just reassuring clients that we have the right to do this. The laws allow it, and our judges have even said how vitally important it is for us to do it. So here is our New York judiciary quote. No government agency has the right to complain that middle-class people choose to voluntarily inflict poverty on themselves, when it is the government itself which has established the rule that poverty is a prerequisite to the receipt of government assistance in defraying the cost of ruinously expensive but absolutely essential medical care. And I have to say, I'm also licensed in Connecticut and New Jersey, and their judicial system has not been nearly as protective, and our ability to protect assets and secure care in those states is significantly compromised because of it. And so New York is a really important jurisdiction. And if you ever consider moving out of state, it's fine to move out of state. Just know you can always come back to New York if you ever do need to access our New York State Medicaid program. Okay. All right, so we have our Medicaid transfer rules, and I'm going to skip the slide and come back to it later. Big picture, we have nursing home rules, which Medicaid calls institutional care, and we have home care rules, which is called community care. The institutional rules are stricter and harsher. The reason for that is the federal government has certain requirements the states have to adhere to, or they lose their matching funds from the federal government. And the matching funds are significant. The federal government pays at least 50% of New York State's Medicaid costs, if not higher. And so there's a 5-year look back if you seek Medicaid coverage of a nursing home stay. And what they are looking for in that period are uncompensated transfers, which are generally known in regular plain English, gifts, and gifts not to a spouse. Spouses are exempt. So spouses get to freely transfer assets between each other without penalty, but a gift to anyone other than a spouse creates a penalty period based on the amount and dollar value of the gift. So if you've gifted within 5 years, it doesn't mean you're ineligible for the next 5 years. It means that you may be ineligible for a period of certain months, depending on the size of the gift. And there are some other people that you're allowed to gift to without penalty. You're allowed to gift to any disabled person or a trust for their benefit if it's for their exclusive benefit. And it doesn't even have to be a family member. So that's another protective class besides spouses. But then there's Medicaid community care, and currently Medicaid community care has no look back. And that's another thing that New York's amazing at. The federal government says the following to states: you have to impose the 5-year look back to nursing homes. You can impose the 5-year look back to home care as well. Well, New Jersey and Connecticut and Florida, again, those are states that impose the 5-year look back to both home care and nursing home care. New York presently has no look back for home care. That's historically been the rule always in New York. In March of 2020, right as the shelter-in-place order came down, our New York legislature for the first time passed a 2.5-year look back for home care that was supposed to roll out in October of 2020. Well, fast forward, 3 weeks, and all the states got emergency pandemic funding from the federal government, and a condition of that funding was that they not change any of their Medicaid programmatic rules. And because of that, New York State, as long as this emergency funding has continued, has delayed the adoption of this 2.5-year look back for Medicaid home care. Our current earliest adoption of that is going to be October of 2022. If you think you might need home care in the near future, now is a really good time to be applying for Medicaid home care, because we can grandfather you in if we apply and secure Medicaid before October of 2022. If I were a betting person, I'm going to guess it's not going to become effective October of 2022, and that'll again be extended to January 2023. But I can't bet with my clients' legal plans, and so it's just, we've been trying to rush people into the Medicaid program for community care in case this 2.5-year rule comes into being. Okay. All right. So when we meet with clients, we need to first figure out, are you on the nursing home side of the page or the home care side of the page? Because depending on what side of the page you're on, totally different rules apply. But 90% of our Medicaid applications are for home care. Why? Who wants to go to a nursing home? Like no one. No one has ever walked into my office and said, Moira, can you get me a room at the local rehab nursing home center? It's really something I've been wanting to make sure that I spend my final days in. Like that is said never. What is said always, and my own parents were this way, is that they want to remain in their homes through their entire lives, that they never want to go into a nursing home. And so we're always thinking Medicaid community care, because that's the program that provides the home care benefit. And that's the program that doesn't penalize you for protecting assets ahead of time. And so these are the asset limits, and they seem really unattainable. A single person has to have less than 17,000 in assets, a married couple less than 25,000. Who can live in New York with that little amount of assets to their name? And same with the income. Medicaid will say on its face that a single person is not allowed to secure more than $954 a month, and the rest has to go to all of their care costs as a spend down. And a 2-person household gets a little bump up to closer to $1,400, but still, how do you live in New York State with less than $1,500 a month in income to support yourself? So we are here to calmly reassure people that we have ways to protect the assets so that our clients can retain this paltry amount of assets, qualify for Medicaid, but still be supported. And then there are different rules that apply to income, and we can secure trust protection for the income as well. And this is where my clients' heads start to spin in terms of the various trusts involved. And so compare nursing home. Nursing home, again, the asset limit, you have to have just under 16,000 if you're single applicant. The community spouse in a nursing home, there are some federal nursing home rules that protect community spouse assets. So you're able to hold on to $75,000 roughly. But the income is the real drawback. If we have a single applicant to a nursing home, there's no community spouse, we are losing all of that person's income except for $50 to the cost of care. There's no way to protect income from nursing homes if a person's in a nursing home, unless there's a community spouse, and then we're able to secure a minimum of roughly $3,500 for the community spouse. It can be a little bit more if the income legally belongs to the community spouse, but if it legally belongs to the applicant, it's going to be lost to the cost of care. So again, nursing home, the asset rules are harsher, the income rules are much harsher, and we're always thinking home care because that's where our clients want to remain. And when I say home, we can have home care delivered in independent living and assisted living. So it doesn't have to be a single family residence. It can be an apartment or a unit in a community. Okay, just a quick trap for the unwary. Medicaid will say that certain assets are exempt. I'm going to plead and try to get you all to remember that this is a fake exemption. I call it a temporary exemption. It's only exempt when my client's alive. Medicaid gets repaid upon death from the estate. If you ever hear about Medicaid taking someone's home, it's because they relied on this exemption. So up to $955,000 of home equity is exempt if you're applying for Medicaid, which makes it seem like, oh, Maura, why are you recommending me transfer our house to a trust? Like, that makes zero sense. If my home is worth $700,000, I'm well under this equity exemption. The problem is that with this equity exemption, they're going to put a lien against the home. And even if they don't put a lien against it, the executor is required to notify Medicaid of the death and affirmatively ask them for how much the estate owes them. And if the executor doesn't do that, they have personal liability for that debt that was left unpaid to the Department of Social Services. Okay, so Ruth Fuller has a raised hand. Ruth, I'm happy for you to unmute and ask the question.
Your voice has changed. You're hollow and it's all echoing. So I don't know if that's going on your recording, but I can't understand you.
Joey,
so something did happen with your voice more. I can still understand you, but I don't know why that happened.
You know what I'm going to do? I'm going to switch my, let me go to my Wi-Fi and switch to a different network.
Yeah, it just kind of, your pitch changed and it is a little, it's different. It's just different. I don't know. I can still understand what you're saying, but it's a different pitch and it's a little bit harder maybe to hear.
It's severe at my end. It's a lot of echoing.
Oh, like an echo. At first there was like an echo. Yeah.
And it also sounds like you're underwater.
Okay. I just switched networks. Is this any better?
No.
No.
Okay. Let me see what I can find in terms of a potential headset situation.
It happened when you switched a page, so I don't know if that has anything to do with it.
You know,
I also don't know if this is showing up on your recording then as the same kind of a recording, because it wouldn't be of any value to anyone who can't hear now to watch your video then if it's in the same, if it's in that as well.
Certainly very likely then if it's happening and if multiple people are hearing it this way, you're exactly right. So why don't we pause for one moment and what I might do, because this sometimes solves things, I might exit and come back in.
Okay.
And see if that works.
That's a good idea.
I will be back. Let me stop.
Thank you.
No, thank you, Ruth. I'm sure it felt like, you know, to interrupt for that, but I really appreciate it. I'll be right back.
Thank you.
Thank you everyone for your patience. Maura has been a board member of ours for quite some time, and she's always partnered with us at the Alzheimer's Association to present these very important presentations. We know at the association how important it is to plan as we get older, and not even relating to Alzheimer's in general for anyone who is aging, it's good to plan and think about our future. So we're grateful to Moira to have her expertise. And, you know, please, again, when she comes back, feel free to enter questions into the chat. This might be a good moment to think of any questions that you do have. You might want to either jot them down or, you know, write them into the chat so we can make sure we get to them later. I remember one summer we had Moira did a presentation. We had so many questions that we did just a Q&A based on her presentation. You know, we had an hour Q&A with Moira, and she could answer everyone's questions. So please feel free to, you know, enter any questions that you do have.
Okay, I've left and I've come back in. I've also added a headset. I'm curious if any of that helped.
It helped a lot, I would say. Okay. What do you all think? Anybody else feel it helped a lot?
Much better.
Much better.
Okay, right. Thank you very much. Okay, so I'm going to come back here and slideshow from current slide. Okay, so when we do asset protection in this area, we're often thinking Medicaid home care and getting clients below the asset levels. We always focus first on the asset levels because it's your assets that determine your eligibility, not your income. So I often ask clients at the start of a conversation, okay, let's go over your assets. And they always tell me about pension income and Social Security income. And I said, okay, good. We're going to get to income, but let's focus on what you own and how you own it and how to protect it, which is a long way of getting back to the original question that was presented in the chat. So when we preserve assets, these are our 5 major options to choose from. The first thing that we can do are just outright gifts to the adult children. The second thing we can do is an asset protection trust. The third thing we do to protect income is a pooled income trust. The fourth thing we do is spousal refusal. And then the fifth thing we're looking for are any truly exempt transfers. So when we left off, I believe I was talking about the temporary exemptions you don't want to rely on. And I highlighted the house because that's the most significant mistake clients never want to make. But there are some exempt transfers that are truly protected even upon a client's passing. And so I'm just going to try to quickly go over the pros and cons of each of these strategies. Here is the one pro to an outright gift, especially because it's typically being made to adult children. It's simple. It's the only thing in its favor. It's a really simple thing to do. Then you see the laundry list of negatives of that. There's often built-in capital gain on the assets transferred to the adult children, and there's really negative income tax consequences for outright gifts. There's no asset protection. I'm interested in protecting my client's assets from Medicaid. When my client wants to transfer them to adult children or has already transferred them to adult children, I often have to come and clean up a mess when that adult child gets divorced, is sued in a business, litigation, or passes away and the asset, passes to an in-law. So there's all these ideas that the adult children are going to hold it for mom and dad. And they might, but then there are all these unintended consequences, even if you have really trustworthy adult children. And then not to mention even college funding, when those parents own more assets, but they're really holding on to them for someone else. The college financial aid office doesn't respect that particular explanation for those assets. So there's just all kinds of unintended consequences. So we talk about outright gifts with clients a lot. We very, very rarely end up doing them. Here is what we do.
Or there's a quick question, if you don't mind.
Oh, sure.
Okay.
Sure.
It says gifts to children. Is there a yearly cap amount that each gift can be given to each child and can
Great
also
question.
be to grandchildren?
Great question. So those annual gifts, it's called the annual exclusion gift. It's an IRS rule relating to what you're allowed to gift without having to report the gift to the IRS. And there's a lot of misconceptions even in the tax world about gifting, and I won't go down that rabbit hole too much, but just know we're all allowed to give up to $12 million per person right now without owing a gift tax. But the extra amount we're able to give that doesn't even count against that 12 million is $16,000 per year per person. We can give it to all of our children and grandchildren each and every year. It's what I call the low-hanging fruit of estate tax planning. It's an awesomely powerful thing to be able to get out that amount of money from your estate each and every year. Medicaid does not respect that whatsoever. So the first thing you have to understand, big picture, is there's Medicaid rules and there's IRS rules, and they're like oil and water. What you do in implementing an IRS gifting plan is not going to be respected under Medicaid's penalty rules. So that's one of the reasons why we're not looking to like really be focusing on using the IRS as a fail-safe here. Okay, so then returning to income-only trusts, there are so many benefits to them. The principal is going to be protected from the Department of Social Services. The reason why it's protected is our clients give up the right to principal. It's why these are called income-only trusts. Our clients transfer assets to them, and any real estate they transfer, they're able to retain the right to live in. Any other assets that they transfer to the trust, they retain a limited right to receive income produced by those assets. By voluntarily impoverishing yourself in this way, though, you're able to put a safe bubble around those assets, and Medicaid can't count them as available to support your healthcare costs. But they can't be touched while you're alive, except we do allow, if a client feels comfortable, we allow the adult children of the client to be eligible beneficiaries of the principal. And that can allow the client to feel comfortable that if they ever do need to potentially access the funds, the adult child can receive some payment from the trust and pay for the thing that mom or dad then might need. Once we create the trust and fund it, the amazing thing about it is that it gets the clock ticking on that 5-year look back for nursing home care. So when we fully fund all of our clients' countable assets in the trust, we can immediately access home care Medicaid if we need to. If we don't need to, then we don't have to. But getting it in there sooner rather than later is really important in terms of the 5-year look back for nursing home care and the potential 2.5-year look back for home care. The trust assets upon the death of the second spouse get paid out to whomever our clients want. And so they really act as a will substitute. And when we do elder law planning, one of the nice thing about it is we're really making the will inapplicable on the client's death, which means that we don't have to go to court when a client dies to get the will probated. So every elder law plan has baked into it probate avoidance strategies. And so that's just an added benefit, because then the family doesn't have those particular court costs later on. And so there's a few different things that we're able to solve for here. In my view, the major drawbacks is just the initial burden of creating a trust agreement and transferring assets to it. It's a hassle. I'm not going to sugarcoat it. We're here to lead clients through it, but we're not free, so there's some administrative costs. But if you think about having a home in Westchester that might be valued anywhere from $500,000 to $2 million, and being able to transfer it to a trust and protect all of that equity, it's usually more than worth the kind of administrative and legal costs to establish things. Okay.
And the one thing I will say about the word irrevocable, I'm just going to go back to that slide, because that is often what clients, are like, what do you mean irrevocable? It has to be irrevocable, or else if you apply for Medicaid, they'll say, fine, revoke it. And, but please know that our New York law allows even irrevocable trusts to be revoked. And so that's a really amazing thing if you, want to just be reassured that what you do can be undone if your situation changes. The big difference is if you create a revocable trust, you alone get to decide whether to revoke it. If you create an irrevocable trust, you need your other trust beneficiaries to consent to revocation. Well, who are the other trust beneficiaries? Typically, there's a spouse that's named if there's a spouse for a client, and there's adult children. So you have to know your own family and your comfort level. And guess what? Even if one of the adult children is like, no, I'm not going to revoke it. Well, we reserve the right for you to change the trust beneficiaries. We could help you change the trust beneficiaries, and then we could get those trust beneficiaries to consent to a revocation. And also, when an adult child knows that you can change a trust beneficiary, they're going to play along, or they're not going to inherit anything later on. And so you just have a few levers of control that we reserve for our, for you if we ever do this kind of planning. And similarly, when every irrevocable trust has a trustee. The most common choice for trustee is an adult child or multiple adult children. Though my preference is no more than 2, and I really do prefer 1 because it's hard to be a fiduciary and it's even harder to be a co-fiduciary. Well, we allow our clients to change a trustee on 3 days' notice. So if you're ever not happy with anything that the trustee is doing, you think you're not on the same page for some reason, you can always shift around trusteeship. So it's not quite as scary as it initially sounds. And that's probably just a good juncture to pause again, since there was a specific, question about this, to make sure that there aren't any questions surrounding irrevocable trusts.
There are a couple questions, Maura, in the chat.
Okay, so let me stop the share for one moment. Or I think actually, I can do this.
I can read. Okay. I can read you them if you want.
I see one that that was part of the other one, and is being asked now by someone else. Whenever we do trust funding, I'm gonna stop the share. Whenever we do trust funding, we always ask the following question: do you have any plans to refinance the home? Because if you have plans to refinance the home, we want you to do that before we transfer the house to trust. So if there's a mortgage on it and there's no plans to refinance it because you have a great rate, or if there's a home equity line of credit, and again, there's no plan to refinance, there's no problem with transferring the house to a trust, because there's a federal law that protects these kinds of transfers and prevents lenders from accelerating a note that supports a mortgage. So there's no risk of your borrowing going away and being accelerated. The one caveat are reverse mortgages. Reverse mortgages are specifically carved out of this federal law. And so whenever we want to transfer a home with a reverse mortgage already on it, we have to seek lender pre-approval, and it's pretty hard to get. I literally think we spent 40 hours on hold with one particular reverse mortgage lender, and it was just a very difficult journey. The other thing that's very hard to do is to secure borrowing once the house is transferred to the trust, because underwriters at banks really get uncomfortable with irrevocable trust agreements and don't like to lend to them. And even since really COVID, they've even gotten uncomfortable lending to revocable trusts. And we've now had to take houses out of revocable trusts to get lending on them and then put them back into a revocable trust, which is really makes zero sense to me, because a revocable trust agreement is the same as the person owning and controlling it outright. So lenders are really cautious about lending to trust. So we always want people to secure new financing before we transfer to trust. If we have to, we can take it out of the trust and put it back in, but it restarts the look back. And we probably do that once a year for a client that it turns out they actually do want to refi. It shouldn't be happening much anymore with interest rates going up. There's not much benefit to refinancing anymore. But as interest rates really plummeted in the last few years, it would definitely happen. Okay, so then there's a really good question, the next one, about whether a special needs pooled trust like NYSARC differs from the income trust that you mentioned. That's a fantastic question. So yes, it differs significantly. So remember how I talked about for home care, how you have to bifurcate and focus first on the assets and then later on the income? NYSARC is primarily used for its pooled income trust offering. Are there some asset trusts that NYSARC runs? Yes. But the reason why you don't want to use a NYSARC trust for assets, unless you really have no other options, is upon a client's death, the pooled trust company, whether it's NYSARC or a different pooled trust company in New York, and there's lots of them, they get to hold on to whatever assets are left, whatever income is left in the account, they get, and the family doesn't inherit. So for assets, which we're allowed to transfer to private family trust agreements that are these irrevocable income only agreements, we always want to put the assets in there and not in a NYSARC or other community trust, because we want our clients' children to ultimately inherit the assets, not NYSARC. But we're not allowed to put income into an asset protection trust. Legally, you're prohibited from assigning pension income and assigning Social Security income to anyone. It's meant to protect us from having our creditors take our retirement income. But in this context, that's where NYSARC and other pooled income trusts are incredibly valuable, because we're able to deposit the excess income each month into these pooled income trusts, have the trustees pay our bills. And so we put, let's say I have $2,000 a month of income, I'm a single applicant, and I have an excess of $1,000. That New York State Medicaid says, Maura, you've got to give this to us. And I say, no, 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 I'm not giving it to you. I'm going to give it to NYSARC. And then I deposit it each month to NYSARC. And each month I give NYSARC $1,000 of my bills to pay. Less really, frankly, whatever NYSARC is going to charge. And one of the things just in my practice, I don't want to knock NYSARC. It is like the gold standard. It's been around for forever. But because of that, it's also the most expensive pooled trust in terms of their administrative costs. And most of my clients choose a different pooled trust company that has a more economical offering. But NYSARC it's almost like Kleenex for tissue. NYSARC is almost synonymous with pooled income trusts. They are that widely known and respected. Okay, so we get to keep a mortgage on a home. That's not a problem. How does someone decide when to create a trust? In my view, you guys are all gonna maybe think this is super biased and self-interested. I think you meet with an elder law attorney. And many of us, including myself and my firm, offer complimentary initial consults. So do a complimentary initial consult. Review your situation with an experienced elder law special needs lawyer. And what we do is we assess what you own, how you own it, what insurance you have, if any, to cover some costs. And we make some recommendations based upon what we learn in that meeting. But generally, back of the envelope, I truly believe everyone over the age of 70 in New York State should own their home in an irrevocable trust, and probably everyone over 60. But so I'm 52. I think I need to be procuring long-term care insurance or expecting to private pay, because over time, these costs are escalating at such an unsustainable rate. I don't know that New York State Medicaid is going to be able to cover a long-term care need in 2052, 2062. So the older my client is, the more I want them to do this planning, because the more I think they're going to benefit from it. The younger my client is, We sometimes just make sure that they have really good powers of attorney in place in case something, God forbid, happened, you know, very suddenly, a stroke, an aneurysm, some sudden health event that was really unexpected. So that a power of attorney would be vested with the authority to implement a Medicaid plan at that point. In general, the sooner you plan, the more you're able to protect. The later you plan, the more you have to rely on crisis Medicaid strategies. One of those crisis Medicaid strategies, I'll just say for anyone married on the call and listening in, or listening in for parents who are still together and both alive. Married couples often want to use a technique called spousal refusal. So let me explain how spousal refusal works. Let's say there's one spouse who needs care and one spouse who doesn't need care. A strategy could be to transfer all the assets out of the name of the spouse who needs care and into the name of the spouse who doesn't need care. That transferring of assets creates no Medicaid penalty. The spouse that needs care then applies for care through New York State Medicaid. And the spouse that's holding all the assets signs a letter saying that he or she refuses to use his or her assets to support the spouse who needs care. The spouse who needs care then assigns their right to spousal support to the Department of Social Services. And at that juncture, the Department of Social Services cannot look beyond the applicant spouse's income in determining eligibility. They're not allowed to consider all the assets held by the quote unquote well spouse. The problem with that is New York State has started suing refusing spouses. It's something that happened around 8 years ago. For decades, New York State received these assignments and did nothing with them. But because they've become far more aggressive about suing refusing spouses, we only, in my practice and my firm, we only like to use spousal refusal as a last resort. But it's like an easy thing to do. It's kind of like the outright transfer. It's like a really quick and easy thing to do. Just put everything in one spouse's name and apply for the other spouse and you're done. But it comes with a lot of consequences, and married couples should really be thinking about doing planning ahead of time rather than thinking they're going to rely on spousal refusal. Okay, so I see it's 11:02 and I've been talking a very long time. Jody, thank you for putting all of my contact information there. I'm going to briefly just look at a few more questions and make sure that I didn't miss any of them. But I think I got them all. Okay, excellent. I might have missed some when I logged out. Jody, do you see any? Because I don't see the ones that posted in the first part before I left.
There was one question about what's the difference between, you already said that, revocable and irrevocable. One question, I don't know if you answered this or not. Does the house need to be paid off to be put into a trust?
So that's where we do have that federal protection. It does not need to be paid off unless it's a reverse mortgage. And so that's the only type of lending that's an issue. So a traditional mortgage is fine. A home equity line of credit is fine.
Okay. I think you've answered everything. There was one that just came. It says changes to Medicaid 2023.
Yes, for some for the good, some potentially for the worse. So for the good, we have much higher asset levels than prior years. And we had a really, really weird legislative session. And it caused, frankly, a lot of dissension between and among elder law attorneys as to what its impact would be. But New York came really, really close to eliminating the asset resort test altogether and allowing anyone to apply for Medicaid regardless of whatever amount of assets they held. And there were colleagues of mine who were strenuously opposing this because they thought it was going to be a trap for the unwary and lead to more Medicaid reimbursement, because then clients wouldn't meet with elder law attorneys, wouldn't know that Medicaid gets reimbursed upon death from the estate. So there was part of the bar that was thinking very cynically, oh, this is not going to help our clients. It's actually going to really hurt them. And then there were other parts of the bar that thought, oh no, this is going to be really wonderful. More modest people who can't afford lawyers are going to secure care sooner. All of that's to say it didn't happen. But what happened instead was New York really significantly bumped it up. Whereas in prior years, it would scooch up from like 1,500 for a married couple to 1,515, you know, like it would go like really, really incrementally. And now the asset and income levels are going to be a bit more generous, still requiring asset protection planning, but going to be a little bit easier for clients to hold on to some rainy day funds. For the worse, we're just still worried about home care having that 2.5 year look back. We're constantly updating the blog on our website whenever New York extends it. And we're constantly sending out news alerts to clients. Right now it's on the books for October 1. If you think you need care, now's the time to get in, because we know that we can get people care if they apply in the month of September or earlier. And it takes a while to develop a plan. So again, anyone who thinks they're going to need care in the next 3 years, like now is really the time, or is anyone who's concerned that they might need care in the next 3 years. It's a really good time to meet.
Can I ask a question? What does the Medicare home health look like? What is that? What happens with that?
Great question. Because oftentimes people think they're going to receive inferior care if they have it paid for by Medicaid. They think it's like a Medicaid aid. So Medicaid New York pays for the care. They do that by, and this is a relatively last 5-year thing as well, they do that by paying the money to managed long-term care companies. The managed long-term care companies, in turn, have contracts with home care agencies. So it's a regular home care agency that's actually supervising and staffing a case. It's just, if you think of like this as the entire universe of like Westchester County home care agencies, and then you put like a pinprick in the middle, that's how many home care agencies accept Medicaid. So the labor supply of any home care agency in Westchester is the exact same. You just have a narrower list of home care agencies that you're allowed to work with if you want New York State Medicaid to be the payment source. One of the first things that we do when we're retained by a family is make sure that their care is being provided by one of those, 5 or 7 agencies. And COVID, I have to say, Sandra, COVID threw a complete wrinkle in all of this, because we had to, families had to keep loved ones safe. Agencies had to protect employees, throw in really generous unemployment benefits into the mix, and staffing supply just really became short. So I would say the last few years have really tested the ability to staff any home care case. But in particular with Medicaid, our clients had to get very creative. One of the things our clients are allowed to do is hire their own aide and have it paid for by what's known as a fiscal intermediary. And so home care does require, I think, a very committed family to navigating the onboarding and supervision of the aides. And there are social workers out here who can support families too. We work very commonly with geriatric care managers to support a family as they onboard a home care plan. We also have to fight for care. So part of why you need legal representation is not just for the asset protection, it's for the actual care award. Because what New York State has done is put managed long-term care companies in charge of the care award. And they're in the process of revamping that as we speak. And there's a conference in my elder law section about it in 2 weeks. So we'll have a little bit more information after the next few weeks about how the new process for home care awards are going to work. But it's been a major grievance of our elder law community that the managed long-term care companies that get paid a set a rate per patient. So let's say they get $6,000 a month per patient. If they award 24-hour care to that patient, they are taking a bath. They're out of pocket money. So when they come to assess how much the patient needs, a nurse comes to assess. Well, nurses are nurses. I told you about my mom who's a nurse. I love nurses. We go, we schmooze the nurse. We we kind of peek and look at her notes and her recommendations, because she's an employee of the managed long-term care company. And then she goes back and she gives her recommendation to the managed long-term care manager. And we know the nurses recommended 24 hours. And then the manager comes back and tells us that they can only award 8 hours. And we're like, well, hold on, hold the phone. We were there. We saw the nurse recommend 24 hours to you. Why are you saying 8 hours? So those are kind of like some of the things where it's a great program. Many states don't even have 24-hour home care, period. Many states have that 5-year look back for home care. You know, like New York's wonderful. I didn't even tell everyone yet, like New York doesn't even count your retirement accounts toward that asset limit. Every other state nearly does. So I will end there, but just know we are here as a resource. We offer complimentary consults. I have to thank everyone for coming 4th of July weekend. Really, really amazing that people are here during this holiday week.
Thank you.
Thank you so much, Maura. We always appreciate.
Thank you. Thank you so much.
Thank you, Maura.
Oh, you're welcome. Really a pleasure.
Thank you very much.
You're welcome. Bye now.
All right. Bye.
Bye.